Number 2023 CR 29. I think Mr. Walker appears in the office of his attorney, Chris Pate. Jill Gillette appears as Elk County attorney. This matter comes before the court at this time for pretrial conference. Implicitly, the court's also going to need to decide at least two motions that have been filed by the defense. And counsel, I just became aware during this recess I took to join on another device that apparently there's been a new filing in the case of what appears to be a third amended complaint and information, though it is not labeled as such. I have it printed out. I don't know if I understand totally what the implications are of the amendments, but we will proceed further at this time. Regarding the first motion that the court is going to take up this morning, and that is the motion to dismiss or amend. Mr. Pate, if you just summarize for the record here, what are you seeking by this motion?
Well, Your Honor, the third amended complaint filed this morning at 9:31 resolves my motion to dismiss. That the request was that count 3 be properly amended back to a misdemeanor battery on law enforcement. This amended complaint accomplishes that, so this motion is moved.
Well, Mr. Pate, I do not totally agree. Count 3, and the state has had multiple opportunities to clarify this point. Count 3, in the view of the court, does not properly charge battery on a law enforcement officer. It charges battery. There's no allegation in the text of count 3 that identifies that this was a battery on a law enforcement officer. It uses the name of Deputy Annie Bliss, but the reality is the law enforcement officer is an element of this offense. That element is not charged in this particular document. And quite frankly, the amendment, if any, should be to a Class B battery, just based on the language of the charge. Do you disagree with that, Mr. Pate?
Well, Your Honor, actually, I think that is a proper analysis, and the focus of my motion was inexplicably between the first amended and the second amended complaint information. It was elevated from a misdemeanor battery law enforcement to a felony battery law enforcement, and that was the focus of the motion. But I do agree, upon further review, the court is correct. It does not have the additional element of law enforcement in the actual text of the complaint. It has it in the title of the charge, but not in the text.
All right. Despite your earlier pronouncement, Mr. Pate, the court's inclined to grant the motion to amend count 3 to reflect a charge of Class B misdemeanor battery based on the language of the charging document. And again, the state has had numerous opportunities to either enhance or clarify the language of their various charging documents. The court will have this case go to trial on what's actually being charged. And again, it'll be the court's ruling that count 3 will go to the jury as Class B misdemeanor battery. All right. Regarding your other motion to dismiss, Mr. Pate, again, summarize your position in regards to that motion.
Your Honor, we were last before the court on October 14th. At that time, I filed a motion for bill of particulars. The court granted my motion. The court ordered the state to file a bill of particulars 7 days from the date of that hearing, which would have been October 21st. No such bill of particulars was filed. So I just simply filed a motion to dismiss count 1 in line with the court's previous order. I don't even think I needed to file the motion necessarily because the court already made the order. However, I did, so the record was clear. It did come to my attention this morning or actually last night at 6:53, it appears Ms. Gillette did file the bill of particulars. However, I'm asking the court to stick to its previous order, which was that needed to be filed by October 21st, or the count gets dismissed. There was no request for extension of the deadline. I'm just asking the court to enforce its previous order and dismiss count one.
Ms. Gillette, even if this court were to construe the 7 days that the court set forth in this case as 7 business days, you're significantly out of time. I note that you did file a bill of particulars, not just as to count one, which was consistent with the court's order, but apparently in regards to all other charges of the information. So what is your response to Mr. Pate's motion to dismiss?
With all due respect to the court, I had a jury trial last week because I had jury trial set 2 weeks apart by the court on the master calendar. Therefore, I was in jury trial prep, and doing jury trial all last week. So I took time to sit down and do all the bill of particulars stuff, get it ready, and have it filed for today. The way the court's calendars have been for me, I had jury trials back to back, and I've had jury trials 2 weeks apart more than once this year. So I got everything done as soon as I could, as soon as the jury trial was over, because I had other stuff that was also pressing that comes in while I'm in jury trial, such as child in need of care information, which has to be done in a very specific time limit as well. And seeing as how neither of my counties can afford to have extra assistants that can do all of this extra work, I do it myself.
All right, 2 points come to mind. First of all, you're only required to do a bill of particulars in regards to count one, not all counts. So I think that would have restricted the amount of time necessary to respond. And number two, wouldn't the proper procedure have been for you or your office to file a motion for extension of time prior to the expiration of the deadline, so that at least that was on file to request the court to extend the time that the court had originally allowed?
Judge Young, I understood that you wanted a bill of particulars for the entire complaint, and that's what I prepared, was the entire bill of particulars for every charge.
All right, well, that's inconsistent with the court's notes stemming from that hearing. I think the issue was, and the controversy was around the disorderly conduct charge in count one only. I don't recall that Mr. Pate had asked for a bill of particulars as to all counts, but really clarification as to count one. Quite frankly, I understand, Ms. Gillette, your busy calendar and considerable workload that you have, but the court's inclined to enforce its deadlines. The court, in this case, allowed 7 days, and even, again, construed liberally to be 7 business days. You're out of time. And the court, this close to trial, is not inclined to grant the state an unrequested extension. And so the court will enforce its earlier deadline order in the case and will dismiss count one of the information, which is, I think, even under the most recently filed one. Yes, is count one, disorderly conduct, the Class C person misdemeanor charged in that particular count. Furthermore, especially in light of the court's ruling in regards to what is currently count three, court is going to direct the county attorney's office to file, and I think it needs to be specifically designated as Fourth Amendment complaint information, which shows the court's ruling in regards to what is now count three. And because the court has essentially eliminated through dismissal count one, Ms. Gillette, it would seem to the court that it would be useful that the Fourth Amendment complaint simply have 3 counts, 1, 2, and 3, to avoid perhaps juror confusion as to what happened to a missing count 1. I don't see that in any way that the defendant's compromised by a new charging document that simply lists 1 as presumably what is now count 2, interference with law enforcement, survives the Class A non-person misdemeanor involving Deputy Amy Bliss. Surviving would be count 3, battery, a Class B misdemeanor in regards to Amy Bliss. And then count 3, if that's how you elect to number them and list them, would be aggravated battery on a law enforcement officer, charged in this document as a level 4 person felony in regards to Deputy Watts. Again, I just think that it would avoid juror confusion and a possible question in the future. Furthermore, the court has some additional directions that it wishes to make to counsel in this case.
Judge, the way Odyssey works, they don't do it that way. So I'll have to amend every count to something different, and it'll all have to be changed in the Odyssey computers. Because the way Odyssey works, you don't do that. You just have to write that count's dismissed.
Yeah, our case management system is what it is. Ms. Gillette, I have no reason to disbelieve it. Again, I was trying to take a practical approach, but if that's inconsistent with the digital case management system, then I think you need to file the amended document consistent with that system. And I regret that the system's not more flexible in that regard.
Yeah, there's a whole ton of things we can't even charge. And I've had lots of arguments with OJO, and so have all the other prosecutors, that we can't file specific statutes because they're not in the system. You just have to find what's best or closest, and they don't have a miscellaneous to let us fill in what one is.
All right. Mr. Pate, do you dispute that that's how the system works?
I'd probably have to ask my legal assistant, Your Honor, but
Okay.
I don't have any reason to doubt that.
Nor do I. So do what you need to do, Ms. Gillette. We'll deal with it when it comes up. But with that said, the court's going to direct that the state's witnesses may refer, if necessary, to the fact that Mr. Walker's original arrest may have been based. He was arrested for disorderly conduct, though, again, it's not going to reflect that he was charged. But neither party is to refer to the reasons for the dismissal or that the disorderly conduct charge was ever dismissed. Perhaps because we're going to be dealing with counts 2, 3, and 4, maybe the jury will naturally infer that count 1 was a disorderly conduct charge that was dismissed. I see no useful purpose to either side getting into or arguing regarding the disorderly conduct count. But I hope it's clear that there probably needs to be some explanation to the jury as to why there was an arrest in the first place, which I think led to everything that followed. And obviously, since that arrest apparently was based on suspicion of disorderly conduct, it seems only fair that the state and the state's witnesses may refer to that. But I don't want some explanation or commentary as to the reasons for the dismissal or that even the count was dismissed. Any clarification needed about that, Mr. Pate?
Well, Your Honor, that does bring up another question that I can address by a motion in limine if necessary. Other than the fact Mr. Walker was arrested for disorderly conduct, which I think certainly is a relevant fact because we have to discuss why he was under arrest if we're going to deal with the battery and the interference charges, I think it renders his actual alleged conduct before the arrest irrelevant. And I guess what I'm saying is I don't think the state should then be allowed to go in and detail every single thing that happened before Deputy Bliss arrived because it's simply not relevant to whether he committed an interference with law enforcement or a battery on either Deputy Bliss or Deputy Watts. It only serves to prejudice him in front of the jury.
I see your point, Mr. Pate. Your response, Ms. Gillette?
Judge, we can play because everything from the time that Deputy Bliss has contact with him on is on video. So we're basically going to play those videos. And if you don't have to bring in all the other extra witnesses, that'll make the trial much shorter.
Okay.
So.
Essentially, I think where the trial is going to pick up is what happened at the jail. Would you agree, Ms. Gillette?
He resists being handcuffed or going over to the jail beforehand as well. There's body camera from the moment Bliss arrives at the courthouse. So it'd be from the moment that there's interaction with Bliss and him, or Mr. Pate and I can get together and look over the video and determine the exact spot where we start. And then we'll go through everything in the sheriff's office.
All right, now, if you look at your bill of particulars in regards to count 2, interference with law enforcement, 2 of the 3 clearly took place at the jail, refusing to be booked, refusing to answer booking questions. The only remaining fact would be resisted arrest by yanking away from Deputy Bliss. Where did that happen at?
Once outside the courthouse and once in the jail.
Having reviewed the video, Mr. Pate, do you agree?
I'll have to review it again. I think probably. I think I'm not agreeing he did that.
No.
But I think there might be something she could argue at that point. So I think we could probably figure that out.
All right. Well, to me, that's where the video is going to pick up. It's going to pick up at the first allegation by the state that he somehow interfered with law enforcement, and appears to be limited to yanking away from Deputy Bliss, because even the state's own recitation of the facts seems to suggest that's what they're alleging, not any other conduct at the door. And I don't know if that happened during the transport to the jail or still at the courthouse door. I'm a little concerned exactly what yanking away means. I mean, what movement is considered actually resisting law enforcement? I suppose maybe it's obvious from the video. But I do hope council can resolve that issue and start the video at an appropriate juncture. Mr. Pate, I appreciate your confidence that you can do that. All right. I also am going to set a deadline regarding the filing of the amended information in this case. Again, Mr. Ladd, I know you're busy. I just need to make sure that that's on file prior to our trial date. I'm going to set a deadline for noon on November 5, which I think is the day before trial. I think Mr. Padar, already knows what's coming, but I do want to have him to have an opportunity to look over what is going to be labeled as the 4th amended complaint information, just to make sure that it's in compliance with the orders of the court made here today. If you can do it sooner, if your office can get that done sooner, Mr. Lett, greatly appreciated. But the deadline's noon on November 5. All right. I think that given the severity level 4, 8 peremptory challenges apiece, counsel?
I don't mind if there's 8 or there's 6. We've done it both ways.
Judge Lee made it.
Well, based on severity level of the most serious offense charge, that will determine the number of peremptory challenges for each side. I certainly know that level 5 is 8. Check that. Let's get that issue resolved now.
Well, and I think we have potentially another issue, Your Honor, that.
Well, let's resolve this one first.
Well, I think this issue I'm about to raise may impact the other issue. In the second amended complaint, which was filed immediately after the preliminary hearing on November 13th, Mr. Walker was charged with aggravated battery on law enforcement level 5 person felony, which is what I believe Judge Lee bound him over on. The bill of particulars, which was filed this morning, now has that count as a severity level 4. And I just now caught that.
Is that consistent with the most recently filed charging document, which again was just filed this morning?
In the one filed this morning, it's a level 4. In the one we've been operating under from the conclusion of the preliminary hearing on, it was a level 5. And as I look at that closer, it has the same issue as count 3 does. There's no allegation in the body of the text of Deputy Watts being a properly uniformed or identified law enforcement officer.
Well, you make an interesting point here, Mr. Pate. I'm looking at the most recently filed charging document in count 4. While charged as a level 4 person felony, again, there's no reference in the text that this was a battery against or an aggravated battery against a law enforcement officer. Ms. Gillette, I think he's right.
It identifies both of them as deputies.
Yeah, but Ms. Gillette, it's an essential element of the offense. We're just supposed to glean by the word deputy that's not part of their name. I mean, who knows? In today's world, people name their children anything. You just list that individual as Deputy Eric Watts. Are you saying that in and of itself constitutes a declaration that this was a law enforcement officer?
It does when it's described as aggravated battery on a law enforcement officer. If it was a KHP officer, it would say trooper. If it was a game warden for the Kansas Department of Parks and Wildlife, it would say game warden. If it's a correctional officer, it would say corrections officer. I think that the law specifically says, and I want this on the record for appeal, that the complaint should be liberally construed to allow grammatical errors or intent.
How many attempts should your office be allowed to get this right, Ms. Gillette? Should this court reward sloppy work from the prosecutor's office? I mean, you filed multiple amended informations here. Scrutiny of a charge should be made by the prosecuting officer in this case and their staff to make sure that the charge reflects the severity level of the crime that you're intending to charge, with sufficient recitation of facts within the complaint to make it clear exactly what conduct that you're charging.
I think it's clear that they are law enforcement officers, and this is being charged as battery on a law enforcement officer.
Just a moment, counsel. All right, counsel, I'm going to take a brief recess for ruling on this matter. Stay with the meeting, counsel.
May I step away just very briefly?
You may. This will be a 5 to 10 minute recess.
Okay, thank you.
We'll reconvene in just a few minutes. We're in recess at this time. Pause. Ms. Gillette appearing as before. Following this brief recess, the court has before it the pattern instruction setting forth the elements of an offense of aggravated battery against a law enforcement officer or court official. I will state, and I think in support of the court's continuing position, that number 2 requires that the state prove, and therefore, in the view of the court, originally charged, that an individual was a uniformed or properly identified county law enforcement officer. The charging document does not set forth that language. And that it's not just some reasonable inference that could be drawn by use of the term deputy. I think that the state has to actually charge that this was a uniformed county officer or whatever department the person was with. That wasn't done in this case. Therefore, Mr. Pate's oral motion for essentially amendment and or dismissal of count 4 will be granted by this court, because again, the state has had multiple opportunities to clarify this point and bring that charge within the proper confines of the statute in this case. And the court will grant the motion and show that the count 4 is to be amended simply to a count of aggravated battery. Which begs the question, how will that affect severity level given the current language of the charge that Eric Watts essentially was subjected to an aggravated battery, but not as a law enforcement officer, but merely as an individual, given the language of the charge, which was physical contact when done in a rude, insulting, or angry manner, causing great bodily harm or disfigurement. Ms. Gillette, you've handled a number of these cases. Do you know right offhand how that would affect severity level?
And Your Honor, I don't want to muddy the waters anymore, but I'm afraid I'm going to.
Continue to muddy, Mr. Pate.
During the recess, I went and pulled the battery statute and also the preliminary hearing transcript that the court allowed me to have when I was appointed. Judge Lee bound Mr. Walker over on KSA 215413, B like boy, 2, B like boy, and then classified that as a severity level 5 person felony. I then went and pulled the battery statute 215413 B2B. Appears to me to be recklessly causing bodily harm to another person with a deadly weapon or in any manner whereby great bodily harm, disfigurement, or death can be inflicted. And then I went to the penalty section for that, which is in H1 or H2, I'm sorry, H2D like David says that subsection B2B is a severity level 8 person felony. So it appears that the subsection Judge Lee bound Mr. Walker over on does not comport with the severity level that Judge Lee stated on the record. They're two different things. But on the record, he bound him over under B2B, which is recklessly causing bodily harm in a manner where great bodily harm could be inflicted.
Could be inflicted rather than actually caused.
Yes, it's either the alternative means are recklessly causing any type of bodily harm with a deadly weapon or causing bodily harm in any manner where great bodily harm could be inflicted.
Page of the transcript that you're referring to?
47.
Thank you, Mr. Pate.
Starting at line 6, I believe.
I do find that there are sufficient evidence for probable cause to bind him over for arraignment on that subsection. Well, I don't think he got into the detail that you did. I think you're just interpreting the language of the statute here, Mr. Pate. He did say recklessly caused great bodily harm.
Because B2B for a normal person is different than B2B for a law enforcement officer, and a law enforcement officer is a level 5.
Well, right now, I'm not dealing with the law enforcement officer question, but rather, what type of aggravated battery did he bind over on? If you look at the language on page 46, Mr. Pate, there's probable cause that he recklessly caused great bodily harm. That is consistent with the language that Ms. Gillette has used in her most recent charge in count 4. In other words, she's alleging that it was actually caused here, not just done in a manner where it could be caused. I think her position is it was actually caused. Am I correct, Ms.
Yeah,
Gillette?
I agree with that.
All right.
I don't think he says capital B. I think he said B2. I think he had B2A down as actually causing the bodily harm, and that is a 4. B5 is a 5, but he found it was a 5.
But for a non-law enforcement officer, it's an 8, correct, Mr. Pate? Looking at the penalty section?
If the great bodily harm does not actually occur, yes, Judge.
Okay, and if it did actually occur as alleged by the state?
I think that's a 5 if it actually occurred.
It's a
Well,
5.
That was consistent with the finding, probable cause finding made by Judge Lee, and it's also consistent with the charging document, which has been filed by the state, that there was an actual recklessly causing of great bodily harm. So you're conceding, Mr. Pate, that would be a level 5?
With the actual great bodily harm, yes, I would agree that would be a level 5. So I think Judge Lee found that probable cause for that factual basis, but the wrong part of the statute may have been cited into the record.
All right. Well, again, the court's going to make its rulings based on the actual factual findings rather than the legal interpretation of those findings made by the magistrate court. And
The court also found that Deputy Bliss's was a Class A law enforcement misdemeanor. Well, I don't know if he
but
made
he,
it.
but he need not make any findings regarding misdemeanors.
Yeah.
The purpose of a preliminary hearing is to determine probable cause for felonies, not misdemeanors.
And there's only one felony here, Your Honor.
All right. Well, what is now count 4, essentially is going to be treated by this court as a severity level 5 person felony charge involving recklessly causing physical contact with another person when done in a rude, insulting, or angry manner, causing great bodily harm or disfigurement. I don't know if there's really a disfigurement claim here, but great bodily harm to Eric Watts. Quite frankly, given the court's ruling in the 4th amended complaint information, that's how it should read. With proper citations to the appropriate part of the aggravated battery statute and the penalty section as a severity level 5 person felony. So your attempt to muddy the waters, Mr. Pate, I think essentially results in lowering severity level from 4 to 5. Would you agree?
And it may have been a
Yes.
typo. It was a 5 on the prior amended complaint, and I was working after a 14-hour day on this. I think it's a typo.
Judge, I agree after the court's findings that count 4 would be charged as a level 5.
All right. Furthermore, Mr. Lett, you may want to talk to the clerk of the district court just to make sure that you can't renumber a complaint. I know that the Odyssey program has its limitations, but if there's a way it can be done properly, this court would greatly prefer that there be a 3-count Fourth Amendment complaint information without necessarily a reference in that particular document to the dismissal of count 1. If it can't be done, it can't be done. But if anybody knows a way around it, it'd be Erin, our clerk of the district court, and you may want to check with her to see if the system might recognize that amended charging document with essentially renumbering or retooling the charges of the complaint. I don't think that changes the number of peremptory challenges, Mr. Pate, despite your muddy waters attempt. I think we're still at 8 peremptory challenges for each side. It would be the intention of the court to seat 1 alternate. Further, I want to reiterate at this pretrial conference that it's still the intention of the court to limit during voir dire the jury questioning portion to only courtroom participants will be allowed in the courtroom physically. There will be no exceptions. If you're not a specifically authorized court official, you will not be in there unless you're a prospective juror, prospective jurors only. To the extent to accommodate the public, I think there'll be a YouTube broadcast that will be accommodated locally. It's the intention of court staff to set up a room or a facility either at or very near the courthouse to allow the public to view those proceedings. There will not be any spectators during jury questioning. Once a jury is selected and paneled and sworn, then at that point, the court will allow it to just be an open courtroom. As long as there's no disruption by any member of the public, they'll be allowed to fully watch and participate. And Mr. Walker, yes, my prohibition does apply to even your immediate family members. But they can come to the courthouse and they can watch it on YouTube.
A judge requests that there is no recording, live stream, or anything of the jury proceedings. We have had lots of issues with live streaming, everything they can possibly live stream. I have not been notified of any applications for anyone to be able to record the proceedings other than the court and the official court record.
Well, what you're essentially requesting is a closed circuit broadcast to this other room for the public, correct? Rather than a general YouTube broadcast, correct?
Correct.
I'll talk to my staff about it. I see your point, and it's a valid one, and I will address that with the court administration. All right. Mr. Pate, I am sure that there may be other pretrial issues that we need to discuss. Do you have any?
Just a moment, please, Your Honor.
Sure.
I have one, Your Honor.
Okay, we'll address that in a moment.
I don't think I have anything at the moment, Your Honor.
All right. I think Ms. Gillette identified that she may have an additional issue. Ms. Gillette?
Judge, I'll have personal security with me. It's a deputy from a neighboring county. From the moment that I step on courthouse grounds to the moment that I leave due to the death threats against me due to this case. And I ask permission for that person to be with me in the courthouse, even when I'm in the courtroom. I can't do my job and watch my back, same as you can't do your job and watch your back. And it's just one extra person. They've been sworn in as a special investigator for quite a while, working on a different matter for me, because we hired them to do a bunch of technical media work on a case that we needed someone with that capability for. So I'm asking for permission to have the extra security that my office is having to pay for me.
Is this person currently associated with a law enforcement agency?
Yes, it's a Greenwood County deputy that lives in Elk County. It's Deputy Clinton Hanson, who used to be on the force here.
He will be allowed. I'm not going to put any particular limitation on the presence of law enforcement officers. presuming that they have some sort of law enforcement related function that they're attempting to exercise.
Yeah.
With their presence. Yes, so that's a valid request and the court grants it, Ms. Gillette.
Thank you, Your Honor.
And I trust that you're asking this individual even to be seated with you or be present in the courtroom at all times that you are?
I was going to ask for him to be either right behind me in the gallery where he can view the entire courtroom, or because there will be a deputy near the front door, and this deputy will follow me basically to and from my office, to and from the courthouse, anywhere I'm at, just because there's been so many death threats received by my office.
Well, I'm sorry to hear that, Ms. Gillette. All right, I think I've clarified the court's position in that regard. Anything else, Ms. Gillette?
Nothing further.
All right, again, I'll reiterate the deadline for filing of the amended, which will be, I think, the fourth amendment complaint information by noon on Tuesday, November the 5th. And again, if it can be filed sooner, I highly encourage it. All right. Counsel, I'll need you in the building there in Howard, checked in through any security and be ready. I'll ask that Mr. Walker, Mr. Pate, Ms. Gillette, I'll be there by 8:45 a.m. that first morning. If there's any other last minute matters that we need to talk about, we'll have the opportunity to do so before our scheduled start time at 9 o'clock a.m., which I'd like to get started promptly, if at all possible. All right. Thank you all for your time and input to the court this morning. Mr. Walker, this court does have certain dress code expectations for participants during a jury trial. Mr. Pate's a very experienced attorney and handled many jury trial situations. If you have any questions about what's the proper thing to wear, just ask him. And I'm sure whatever advice he gives will be sound and you will follow it. All right. If there's nothing further at this time, the Robert Walker Jr. matter will currently be in recess, and this meeting may be ended for all at this time.